On August 11, 1967, William Mink and his family were asleep in Savannah, Georgia. Mink was woken up by a noise and went to investigate. He found Henry Furman attempting to flee the break-in, and Furman shot William Mink through a closed door and killed him. Furman was found guilty of murder and, under Georgia state law, was sentenced to death.
The death penalty had been in decline since 1935, when the implementation of capital punishment was at its peak, and the U.S. government first began keeping track of death sentences. However, the years following, the use of the death penalty began to drop, which was a reaction to the world just coming out of World War II, where nations' leaders were using the state to kill. Likewise, as the civil rights movement unfolded and crime rates began dropping, executions had become far less frequent. In 1957, for the first time in American history, popular support for the death penalty fell below 50%. However, in the 1970s, the death penalty began to receive a sudden resurrection.
William Furman appealed his case decision, and ultimately his case was heard by the Supreme Court. Furman's attorney, Anthony Amsterdam, challenged the death penalty's constitutionality and the capricious way in which the death penalty was imposed.
The Supreme Court ruled in favor of Furman, and in a historical 5-4 vote, the court concluded that the death penalty itself was not unconstitutional. However, it was unconstitutional on how it was applied. The Furman v. Georgia case led to a 4-year moratorium on all executions until the issue could be considered further.
Although Furman v. Georgia did not abolish the death penalty in the United States, it revealed an unprecedented amount of biases deeply rooted within the current justice system, which opened up a debate of the morality of capital punishment on a national scale, and was vital to the reformation of how the death penalty is applied. Furman v. Georgia exposed injustice in the Supreme Court legal system. In fact, Justice Thurgood Marshall described the death penalty as morally unacceptable because it often targeted people of color, subjects to poverty, the mentally ill, and overall underprivileged members of society. Capital punishment inflicted on one defendant is unusual if it discriminates against one by reason of his race, religion, wealth, social position, or class.
Insights from the civil rights movement of the 1960s led many to believe executions were linked to the practice of racial discrimination. Race of the victim played one of the most significant roles in decisions about who would receive the death penalty or not. For instance, if a person of color killed a white person, they were more likely to be given the death sentence than a white person that killed a minority. David C. Baldas and his colleagues found that race of the victim influenced the likelihood of a death sentence equally as much as legitimate aggravating factors such as murder or the defendant having a serious prior record.
Statistics show that 340 of 421 convicts executed in Georgia were African American.
Furthermore, in the years 1930 to 1968 in southern states, 405 of the 455 men that were executed were black. Not a single white man was executed for rape over the 42-year period from 1930 to 1972 in Louisiana, Mississippi, Oklahoma, Virginia, West Virginia, and the District of Columbia. Overall, in 1987, the court decided that studies showing people of color received the death penalty more frequently than white people did not necessarily mean that any racial bias was involved. So, the death penalty was declared not unconstitutional on grounds of discrimination.
Attorney General Ramsey Clark said, "It is the poor, the sick, the ignorant, the powerless, and the hated who are executed."
The application of the death penalty is unequal. Many of those executed experienced poverty, young age, or ignorance. Also, death row is an extreme punishment. No other discipline imposes so much physical and mental torment. Justice Brennan was unimpressed by the contention that capital punishment was imposed only in the most extreme cases because he noted that in Furman it hardly seemed to suggest that the crime was any more reprehensible than any other murder. Furthermore, Furman's case created more public attention towards the subject of the death penalty, and the attention increased the use of the death penalty overall.
In the year 1972, there was a presidential election between Republican candidate Richard Nixon and Democratic candidate George McGovern. McGovern openly disapproved of the death penalty, while Nixon approved of it. President Nixon asked the FBI to give him cases in which convicted killers killed again after being released. The death penalty was no longer about punishment, but a political tactic, and politicians used it as a way to gain voters. The NAACP Legal Defense and Education Fund began to allocate sponsors in research towards a goal of improving the legal challenge and constitutionality of the death penalty systems based on violations of the 8th and 14th Amendments.
Furman, however, did focus public attention on the constitutionality of capital punishment. The crime rate in the U.S. grew throughout the last 3 decades of the 20th century. The need for law and order loomed large. The Gallup poll revealed that a few months before Furman v. Georgia, supporters outweighed opposers of the death penalty, 50% to 42%. A few months after Furman v. Georgia's ruling, supporters of the death penalty began to outweigh the opposers. There was a shift throughout the entire country. More people have been getting sentenced than ever before. 42 people were sent to death in 1973 in comparison to 149 in 1974.
Furman made capital punishment a more relevant issue than it had ever been before. People who didn't think about the death penalty were now forced to see it every day on the news. Furman's argument was that the death penalty was not fair because the parameters of its imposition varied from state to state. Therefore, capital punishment violated the 8th and 14th Amendments. Justice Marshall argued that the death penalty does not deter crime. Moreover, America's society has evolved to the point that it is no longer an appropriate vehicle for expressing retribution. However, Justice White countered this argument by arguing that capital punishment cannot be unconstitutional because the Constitution expressly mentions it.
Although the justices could not agree on whether the death penalty itself was unconstitutional, they did agree that the lack of consistent standard to determine when capital punishment was handed out was unconstitutional. There were no statutes to guide juries who were given the decision of life or death. Therefore, the verdicts often had no rhyme or reason. Before Furman, all court cases concluded that the death penalty was constitutional. For the first time, the court was challenged to debate the mode of punishment used rather than the certain types. The court concluded that the court holds that the imposition and carrying out of the death penalty in these cases constitute cruel and unusual punishment in the violation to the 8th and 14th Amendments.
Justices largely blame the randomness of capital punishment on discretion, the power of juries to act according to dictates of their judgment and conscience. As a result, the Supreme Court developed two guidelines that states had to follow and refine or create death penalty sentencing schemes. First, the scheme must provide objective criteria to direct and limit sentencing, and second, the scheme must allow a judge or jury to consider reasons not to impose the death penalty.
Many states adopted the Model Penal Code to specify what a jury should consider in choosing an appropriate sentence, drafted by a group of distinguished lawyers, judges, and professors 10 years earlier. Under the code, the conviction of first-degree murder took place and then sentencing took place in another hearing. The code contained 8 circumstances in which the death penalty would be appropriate. In order to sentence it to death, the jury needs at least one of these aggravating circumstances present. Likewise, the 8 mitigating circumstances developed had to be considered, which would make the death penalty not appropriate. These included youth, lack of prior criminal history, or mental illness.
While studying Henry Furman's case, it was discovered that Furman presented various of these mitigating circumstances. For example, he experienced a developmental disorder, and he was also subject to psychotic episodes. Furman was a 6th grade dropout and functionally illiterate and prone to epileptic seizures. Even so, he was convicted and sentenced to death without a chance of parole. By 1976, 35 states and federal governments enacted new capital punishment statutes that retained specific procedures in which cases were appropriate to sentence someone to death.
The post-Furman period has been full of advancements and overall just a volatile era for capital punishment. Due to Furman's case, the direction of the Supreme Court has been towards a reassessment of the legitimacy of the sanction. Furman v. Georgia should not be remembered as the court's failed attempt to abolish the death penalty, because Furman nevertheless had a lasting impact, rendering capital punishment less blatantly racist than it had been in the past.
In the 20 years preceding Furman v. Georgia, the civil rights movement unfurled, and the number of crime rates were controllable. Executions had slowed down and then stopped altogether.
The cruel and unusual punishment clause must draw its meaning from evolving standards of decency that mark the progress of a maturing society. Capital punishment fails to comport with human dignity because it cannot be said to be more of an effective option against recidivism than isolated imprisonment. For not only is capital punishment the harshest penalty that the state can impose, it is also irreversible. It is important to note that a just society must be ruled by reason, and not by terror. No matter how infrequently the punishment of death is invoked, many of those who receive it do not of their own merit deserve better.
Now, execution is only legal in 14 countries worldwide. Great Britain abolished the death penalty in 1969, while Austria, Germany, Denmark, Belgium, and New Zealand abolished the death penalty in the post-war era around the mid-1900s. The power to impose the death penalty in the new nation was left to the individual states, and in 4 years following the 1972 Furman decision, 37 states would find a way to reinstate their death penalties through imposition of standards.
The debate on whether capital punishment in America is constitutional continues to gain more followers every day. Furman v. Georgia did not invalidate the death penalty in the United States, but the case did reveal the unfairness of the current legal system, which led to the much-needed revision of the application of the death penalty, and the case brought more media attention to the topic of capital punishment, which is still a very large topic spoken on in society today.